The Supreme Court does not make laws. We are continuously hearing an outrageous myth. The Supreme Court has ruled this is the law of the land. Please, someone, correct me if I'm wrong. Is not the Supreme Court a part of the judicial branch of our government? The definition of the Supreme Court is found in Article 3, Section 1 of the Constitution of the United States of America. Quote, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." On the other hand, the legislative powers are defined in Article 1, Section 1, Paragraph 1, Sentence Number 1 of the Constitution of the United States of America. Quote, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives." Now let us go back and refresh our understanding of algebra. If all legislative powers are vested in Congress, how much legislative power does the Supreme Court have? The Supreme Court is 9 political appointees. They were not elected by the people. Our Constitution provides that laws will be made by legislators who are elected by the people in the legislative branch. Now let us go back to Article 1, Section 1, Paragraph 1, Sentence Number 1 of the Constitution of the United States of America and pay attention to a different concept. Read it again, but now let us direct our attention to the words herein granted. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Have we forgotten who it was that granted those legislative powers to that Congress of the United States? The sovereign states existed before the federal government existed. The sovereign states created the federal government as a servant, to whom these sovereign states voluntarily delegated 21 duties, which are defined as enumerated powers. The enumerated powers are found in Article 1, Section 8 of the Constitution. The federal government was also told quite clearly that there were no powers granted in any other areas other than those 21 enumerated powers. This clear reservation is found in the 10th Amendment of the United States Constitution, powers of the states and the people. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Please remember that the first 10 amendments of the Constitution are also known as the Bill of Rights. What you will find in the Bill of Rights is a list of prohibitions that were placed upon the servant federal government by its creator, the states. What the 10th Amendment does is basically patch up any possible leaks in the clearly limited powers which the sovereign states had authorized their newly created servant. The 10th Amendment basically says that the federal government is not granted any powers other than those that are enumerated in the Constitution. The states created the federal government and authorized the federal government to perform a few well-defined and very limited functions. The federal government was prohibited from doing anything else. The Constitution is not whatever the Supreme Court says it is. The Supreme Court is what the Constitution says it is. Governor Mark Sanford of South Carolina told the federal government that South Carolina would not implement the Real ID Act. Then other states followed suit. The Real ID Act was not implemented nationwide. Suppose that Congress were to pass a law ordering that all churches were to be closed. Suppose the Supreme Court then ruled that this law was constitutional. Would we obey that law? Should we obey that law? Suppose that you were sitting on a jury in 1850, deciding the fate of a person who was being tried for violating the Fugitive Slave Act by helping a runaway slave. The Fugitive Slave Act of 1850 mandated that states which did not condone slavery were obligated to return escaped slaves to their slave masters. Persons who helped runaway slaves were to be subjected to criminal sanctions. In 1854, the Wisconsin Supreme Court declared the Fugitive Slave Act to be unconstitutional, without regard to the rulings of the federal government. The Vermont legislature approved the Habeas Corpus Act, requiring Vermont judicial and law enforcement officials to assist captured fugitive slaves. Jury nullification also took effect, as local juries acquitted people who were quite proud of violating the Fugitive Slave Act. Ultimately, the Fugitive Slave Act was not enforced in any state where slavery was not condoned. At one time, America was the force for freedom that punished people who obeyed immoral laws of tyrants. The Nuremberg trials were just one example. "We were just obeying orders," was the common excuse at Nuremberg. How did that work? Watch the old newsreels, and you will see them laid out on slabs with the nooses still around their necks. Watch the history lesson for future tyrants on YouTube. This video will help refresh our memories. Nuremberg will happen again. Tyrants need obedient troopers while they are gaining power. They kill them later, but whoever the tyrant allows to survive will still meet justice as soon as the tyrant fails. Legal means condoned by government. Illegal means not condoned by government. The Boston Tea Party was illegal. Everything Adolf Hitler did was legal. Hitler's words were the laws. The Declaration of Independence was illegal. In the final analysis, no tyranny will ever condone the effective defense of freedom. Our Bill of Rights is replete with phrases such as, "Congress shall make no law," and "shall not be infringed." King George said our founding fathers were traitors. Hitler called the advocates of liberty traitors. The tyrant's definition of patriotism is the support of tyranny. Moral people cannot learn about what is right or wrong by listening to politicians or by listening to the political appointees of those politicians, even if they are judges. In 1820, Thomas Jefferson wrote, "To consider the judges as ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy." In denying the right of the Supreme Court that usurps the exclusively explaining the Constitution, I go further than others do. This quotation from the Federalist of an opinion that, quote, "the judiciary is the last resort resort in relation to other departments of government, but not in relation to the rights of the parties to the compact under which the judiciary is derived. If this opinion is sound, then indeed our Constitution is a complete act of suicide for intending to establish three departments, coordinate and independent, that they might check the balance one of another. It has given, according to this opinion, to one of them alone the right to prescribe rules for the government of the others, and to that one too which is unelected by the independent of the nation. For experience has already shown that the impeachment it has provided is not even a scarecrow. The Constitution, on this hypothesis, is a mere thing of wax, to be in the hands of the judiciary, for they may twist and shape it into any form they please. That was written by Thomas Jefferson to Spencer Rowan. In 1798, Thomas Jefferson and Madison drafted the Kentucky resolutions and the Virginia resolutions relative to the Alien and Sedition Act. Thomas Jefferson wrote, "Resolved that the several states composing the United States of America are not united on the principle of unlimited submission to the general government, but that by compact under the style and title of the Constitution for the United States and of amendments thereto, they constituted a general government for special purposes, delegated to that government certain definite powers, reserving each state to itself the residuary mass of right to their own self-government, and that whensoever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. That to this compact each state acceded as a state and is an integral party, its co-states forming as to itself the other party. That the government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have been made its discretion and not the Constitution, the measure of its powers, but that as in all other cases of compact among powers having no common judge, each party has an equal right to judge for itself, as well as infractions as of the mode and measure of redress. The important and obvious reality is that the Alien and Sedition Act, the Fugitive Slave Act, and myriads of other outrageously unconstitutional usurpations have been perfectly acceptable to the Supreme Court. The most outrageous unconstitutional usurpations of our time are Obamacare, the Patriot Act, and the NDAA, the National Defense Authorization Act. Any semi-literate with an IQ above room temperature could have quickly determined that none of the usurpations mentioned here are even close to being constitutional. We should understand that the Supreme Court will never protect us from federal usurpation. The Supreme Court is a part of the federal government. All of the Supreme Court justices are political appointees who got their jobs from the federal machine. Anyone who thinks that the Supreme Court will protect us from federal usurpation would have to believe that the fox will guard his hen house. Thomas Jefferson said, "The price of freedom is eternal vigilance." I add, the battle for liberty is never won and never lost. The battle for liberty always continues. It is never too late and never soon enough to defend freedom. No matter how enslaved we are, we always have hope. No matter how free we are never safe. Nothing ever limits the government except the people. Any generation that fails to defend freedom will lose it. The next generation will have to shed blood to gain it back. When the defense of liberty becomes a crime, tyranny is already in force. At that point, failure to defend liberty makes slavery a certainty. Please view the nullification playlist. No one has a duty to enforce injustice, regardless of any unjust laws, and regardless of the instructions of judges and bureaucrats or even the President himself. All public servants have sworn an oath to support and defend the Constitution. Anyone can swear that same oath without regard to any status in or out of the government. If anyone is called for jury duty, or if anyone has been instructed by any governmental agency to perform any function, they can swear the oath to support and defend the Constitution before responding. Every day, courts require people to swear an oath. They will put people in jail if they violate that oath. Can the judge order someone to violate an oath? Tell the judge that you have sworn the same oath that he has sworn, and that you will honor your oath even if he violates his. A sheriff has more authority than the president when he is in his jurisdiction. The states created the federal government and gave the federal government very specific and limited powers. If the federal government exceeds the limits that were placed upon them, it is the duty of the juror, the sheriff, the legislator, or any citizen to resist that usurpation. If the jury must rule according to the judge's instructions, then why are they even there? If the jury is there simply to rubber stamp or to dignify the ruling of the judge, if that is our system, then there is no such thing as a trial by jury. In a free country, the power is in the people. The judge is a government employee. Are we no longer concerned about justice? Jury nullification is a way to allow the natural law to prevail over government-legislated tyranny. Government does not give us our rights. Our rights are inalienable and are endowed by our Creator. The assertion that rights are provided by law is saying that we have no rights except what the government grants to us. There are 4 boxes of freedom to protect your rights: the ballot box, the jury box, the soap box, and the ammo box. It seems as though there are none of the above that are not under attack. What does that mean? You only have the rights that you are willing to defend.